So, hey everyone, welcome to Philly IGDA February meeting. Let me get us started with a bit of info about what the IGDA is and who we are. My name is Adrian Sandoval. I am the chair for the Philadelphia chapter of the International Game Developers Association. We are a global organization that is dedicated to the enrichment and advocacy of game developers. Here in Philadelphia, we are dedicated to supporting our fast-growing professional network, as well as our very vibrant indie and academic community as well. If you'd like more information on the IGDA as an organization, as well as information and benefits surrounding the organization, please head over to igda.org. As for us here in Philadelphia, we hold monthly events such as this one on the second Tuesday of every month. So please be sure to follow us on Facebook and Twitter, and to check out our website at philly.igda.org to keep up to date on events as they are happening. One last thing, we do have a code of conduct, which you can read in full at our website, but please keep in mind that all of our events and communities are safe and inclusive spaces, and please respect each other in your communication here and our other events, as well as online spaces such as our Discord. Tonight, it is my pleasure to introduce Stephan Matanovic. Stephan is a business and intellectual property attorney who has represented clients in matters surrounding technology and data security, as well as trademark and intellectual property. But I'm going to turn it over to him because I am sure he can do a much better job of introducing himself and his history. Thanks again for being here with us tonight, Stephan.
You're very welcome, and thanks for the kind introduction. As Adrian said, I am Stephan Matanovic. I'm a lawyer. I'm also the father of a bunch of gamers and counsel to a number of game companies. So I wanted to talk tonight about a couple of business and intellectual property issues that I find have been relevant for my clients over the years. I've been practicing now for 22 years. So let me launch my slides and we'll go through that. I'm going to share my screen so you'll see my slides on the screen. What I would like to do is, I know there will be lots of questions based on my talk tonight. I would ask you to please reserve those questions until the conclusion of my sort of prepared remarks. I'd love to have a Q&A at the end. There's as I understand it, there's a Q&A function in this version of Zoom. Please start populating that queue with whatever questions may come up during the presentation so that I can answer them in time. So I'm going to share my screen now and we'll get started. All right. So as you can see, I have titled my talk tonight, Trademark Copyright, Online Privacy, and WTF is Section 230. These are, I think, very pressing questions, both for specifically for the gaming industry, but also for anyone looking to do business on the internet. All of these topics intersect and overlap basically any aspect of your life on the internet, whether it is just merely as a user, as we are tonight, we're using a service on the internet, or as someone who either is or plans to make a living using the internet. And these days in the world of pandemic, basically that's most of us who aren't working, manual labor jobs. If we're working on the internet, all of these issues will impact us. So first, of course, there had to be a disclaimer because I'm a lawyer. Please register. There is the URLs on the screen. There's I've created a landing page. I will send my slides to anyone who registers. I'd love to share my content tonight. I understand this is also being recorded, so we can share that content after the fact. Next, this presentation is for informational purposes only. It is not legal advice, and no attorney-client relationship is formed. My malpractice insurer makes me say that just so that nobody believes that this conversation will engender a specific attorney-client relationship. If we want to talk about your specific business or your specific idea, I would love to do so. Let's just do so after our talk. All right, who am I and what am I doing here? Again, my name's Stephan. I attended the University of Virginia and then Temple University School of Law. I've been practicing now 22 years, all of them here in the city. I live in Old City with my family, and I am the managing partner of the Philadelphia office of the law firm Bailey Duquette. We are a full service nationwide firm founded in New York, but now in many cities across the country, including Philadelphia. Our local office is at a co-working space at 21 South 11th Street. So 11th between Market and Chestnut, if and when post-COVID we can ever get together in person again. All right, tonight's topics, as the title alluded, I want to talk a little bit about some intellectual property issues, specifically trademarks and copyrights. I want to talk about online privacy, so GDPR and CCPA and beyond that. And lastly, I want to talk a little bit about Section 230 and why you should care that our government is considering changing it. Again, a lot of my talk will be focused on US law. It's my area of practice. And I am a US-based lawyer, obviously. There are international implications, certainly with GDPR, but most of the discussion that I will be having tonight centers on US law, just for clarification purposes. All right, first a basic primer. What is intellectual property? It's basically the intangible creations of the human mind and the intellect, things that you create with your mind, but don't necessarily manifest in physical goods. The law gives people who create ideas or intellectual goods an exclusive limited period of time to exploit those goods. And some examples of intellectual property are patents, trade secrets, trademarks, and copyright. And tonight, I want to talk specifically about the last two, trademark and copyright, because they have the biggest impact day to day on how we as people who live on the internet transact business and engage in entertainment, everything from how you buy your groceries to the meme site that you check in with in the morning, to how you communicate with others, whether it's through Discord or Twitter or some other tool. So what is a trademark? A trademark is a recognizable name, a logo, a design, or an expression that identifies the source of a product. What does that mean? It is a distinctive mark that creates an unmistakable identification of the source of a good or service. So in the United States, trademarks are registered with the United States Patent and Trademark Office. And a trademark can be registered if it is distinctive. That is, it is the source of the product is readily identifiable. And distinctiveness occurs on a continuum. That is to say, inherently distinctive, a really unique name is on one end of that continuum, and generic and descriptive marks are on the other end of the continuum. And everything else flows between it. So descriptive marks or generic marks must acquire distinctiveness through a secondary meaning. That is, consumers come to recognize the mark as a source of a source indicator. A generic term, such as a software product, for example, called software, could never be registered as a trademark. However, a software product, and I'll use an example here of a mark that exists, Dropbox, that does not describe what the software is. It may describe what the software does, but it doesn't describe what the software is, and it is therefore protectable. These are some examples of trademarks that have, varying examples. Coca-Cola, for example, that word and the color and the swoosh, those are separately trademarked. Similarly, the 6 colors apple in the middle, immediately you know that that's Apple Inc., formerly Apple Computer Inc. That's their original 6 colors logo. The new ones most new machines just have a monochrome logo, but that design with the apple bit, with the bite out of it, that's unmistakable as the source. On the left, the red tab on a pair of jeans. Anywhere you go in the world, somebody's going to know that red tab on a pair of jeans is Levi's. That is a trademarked, both the color and the shape of that logo are trademarked because they unmistakably tell you where those jeans come from, who manufactured those jeans. Those are some examples. What do you get when you register a trademark? Well, you get a bunch of exclusive rights, including the exclusive right to use the mark with the products or services for which it's registered. So for example, I'll go back here. You can sell jeans in the case of Levi's. You can sell t-shirts. You can sell other clothes. You can't manufacture soft drinks because Levi's is not a soft drink manufacturer. Similarly, Coca-Cola can't manufacture jeans, but you get the exclusive use for that good. And the owner of a registered trademark can prevent unauthorized use of that mark with regard to services or products which are colorfully similar. That's the test. The hallmark is whether a consumer will be confused in the marketplace as to the source of the origin of the product. Here, I want to take a short detour to talk about work for hire, which is a concept in the law that says if you are hired, and this is especially relevant if you are a freelancer or you run a consultancy where you are retained by another party to create an app or a game or a component for an app or a game, for example. Because the question of who is the owner of the mark comes up here. Typically, the person who creates or invents a trademark has ownership of that mark. It's the same with any intellectual property. However, in many consulting agreements or employment agreements, there is a work for hire clause, which says that work performed for hire, work that under the contract is performed for hire. That is, anything that you invent, essentially, is the property of your employer or the party to whom you are contracted. So for example, if you have a software consultancy and you're retained to create an app for someone, and you, in the context of that, invent a name for your app that is subsequently trademarked, you don't own that app, you don't own that trademark, your employer or the hiring company does. That is always something when you're going through these types of agreements, whether you're on the hiring side or on the hirer side, or the hiree side, excuse me, you need to be aware of, because things that you invent aren't always yours. Of course, how is a copyright different from a trademark? Well, a copyright gives the owner of a copyright the exclusive right to reproduce or make copies of a creative work, usually for a limited time. Creative work may be things like literary works, artistic works like a painting, educational works, musical works, or, relevant here, code. Code is considered by the Copyright Office to be a literary work, so you can literally copyright your code. Now, a copyright attaches the moment you record or reduce your idea to some kind of tangible form, whether it's typing in the form of code, in the question of code, typing it into a computer, recording a musical performance, or writing a sonnet. The moment it is created, your copyright attaches. However, and by attaches, it means your copyright exists and you don't need to register it at all with the Copyright Office. However, registration makes the notice, puts the public on notice that you own the copyright. So if, for example, you write a song, that song is yours and you have the copyright on that song, but if you don't register it with the Copyright Office, someone else could invent or come up with the exact same song and they wouldn't know that it's your copyright. So in order to prevent inadvertent duplication and inadvertent infringement, it is best practice to register all of your copyrights. Copyright protection in the US lasts for 70 years after the death of the author. They call that the Disney extension, so that Walt Disney Corporation lobbied hard for copyright, the copyright laws in its current state. Here again, the concept of work for hire matters, because if the work was work for hire, then the copyright persists for 120 years after the creation, or 95 years after the publication, whichever is shorter. When the works in question were created before 1978, the rules are really complicated and they've been superseded, but the maximum copyright you can get for works created before 1978 is 95 years from the date of publication. And generally speaking, works created before 1926 are considered to be in the public domain. That is, you can use them at will. What is the fair use doctrine? This is something that comes up constantly. You see it in sort of the mainstream media. You see it every time someone complains about being demonetized on YouTube, or when they get a copyright strike. Fair use copyright is a doctrine in US laws that permits the limited use of copyrighted materials without, and this is important, without having to first acquire a license or permission from the copyright holder. Fair use is important because it's a carve out that allows you as a creative person to use someone else's copyrighted material. So examples of fair use include commentary, search engines. This is like how Google exists, basically. Criticism, so you are allowed to write the New York Times review of books is criticism, and you're allowed to include paragraphs from the book. Parody, this is an important one. Weird Al Yankovic made an entire career on the fair use parody exception. News reporting, research, and academic scholarship. Fair use gives you a carve out. You're basically using unlicensed copyrighted material from another author's work. And there's a four-pronged test that courts will apply to looking as to whether or not you fall within a fair use exception. The first prong is that the purpose and character of the use. The court will look at whether the uses are of a commercial nature or if it's a nonprofit or for educational purposes. Now, there's a Supreme Court case that says just because a use is commercial doesn't mean that you're automatically outside of fair use. However, a commercial use will be scrutinized much more rigorously than a non-commercial use, for example. Next is the nature of the copyrighted work and what is used. The third prong is the amount and substantiality of the portion used in relation to the copyrighted work. So if you're only taking a snippet, like a sample in a hip hop track, for example, versus the entirety of a melody. So like Blurred Lines, the Robin Thicke song, was found to have infringed on Marvin Gaye's on a Marvin Gaye copyright because they lifted the entire melody of the song. And lastly, the effect of the use upon the potential market and the value of the copyrighted work. Does the use diminish the value of the actual copyrighted work? If they interfere with the copyright holder's ability to market their product, it is much more likely to be found not a fair use and not following the fair use exception. So that's a short primer about intellectual property. I know I was very high level there. There's not, I did not drill down into a lot of detail. I could talk about this topic for literally for days. So don't feel like I was at all comprehensive, but I wanted to give you a good overview. I want to save significant amount of time for the next two topics because they are, in my view, potentially more relevant and certainly they pose a greater existential threat to most business on the internet because of the amount of penalties that are able to be levied. So don't take the brevity of my remarks about intellectual property to be a comment on the value of that realm. It's merely, I want to make sure we cover all of our topics tonight because they're all, in my view, equally important. So the first topic in the discussion of data privacy is GDPR and CCPA. If you have had any kind of online account in the last 2 or 3 years, you've absolutely gotten an updated privacy policy based on GDPR and CCPA. Now, what are those two acronyms? The first, GDPR, is the General Data Protection Regulation, promulgated out of Europe. And the second is the California Consumer Privacy Act. They are two privacy frameworks, one in the EU and one in the state of California, that are designed to protect individual users and consumers and safeguard their data and to give them certain rights. It's important to understand how these laws do what they purport to do. They're both what's called long-arm statutes. That is, they expand the jurisdiction of a court beyond the borders of the country in which the court is found. In the case of the GDPR, it's Europe, but the example stands. So typically, a court can only exert its power within a country or territory. The law creates what's literally called a long-arm statute that allows you to go outside of the borders to exert the court's influence outside of the borders. And it allows citizens of the EU or residents of the EU or citizens of the EU, wherever they happen to be in the world, to be afforded the rights and privileges under the GDPR. GDPR went into effect on May 25th, 2018, like it says there. And it was intended by its framers to create a framework to allow individual users to know, understand, and to consent to how data is collected about them. Their mantra is, I quoted it there, the question of privacy by design. CCPA followed about 2 years later. And although it differs in some very important ways that I'll get to in a little bit, it is the California analog to GDPR. It strives to accomplish a lot of the same things. Because in this country, we don't yet have a federal privacy mandate, although I think with the new administration that just took power in January, the potential for that is certainly greater. We don't yet have a federal mandate on privacy, but because of the actions of certain large corporations, first and foremost Microsoft, which made the decision to apply CCPA across the entire United States, we now have a de facto national standard based on CCPA. In other words, if you're doing business on the internet and you decide you want to deviate from CCPA, my advice to clients is you better have a really compelling reason, or courts are going to ask you why you did that deviation. And we can get into specifics about maybe how you might try to argue that you're outside of CCPA in a bit. All right, GDPR really changed the privacy landscape worldwide. Before GDPR, I mean, you've experienced this, I'm sure. Anytime you downloaded an app or loaded an app on your phone or signed up for a service, you never really knew where your data was going, who was going to have access to it, who was going to be able to buy and sell it, et cetera. GDPR changed all of that, and it changed fundamentally the way companies interact with customers, employees, and then importantly, their vendors. And it's had follow-on effects across the world. Brazil has implemented a similar scheme. There are other US states that are looking at it. And of course, California. Those are the biggest highest profile ones. So here's some examples, and this is why I say it poses an existential threat. Here's some examples of GDPR enforcement in the first 2 years of its existence. The first is in Germany, where a social media network was fined 20 million euros, or 20,000 euros, excuse me, after 800,000 emails were found stored in plain text, and they were lifted right out of the server. There, the fine, you'll notice 20,000 euros is not a huge fine. What distinguished the response here is that once they figured out that they'd been compromised, they immediately notified everyone, all of the affected parties, and they took very quick and prominent responsive actions to try to mitigate the harm. Not so much this example in Portugal, where a hospital was fined significantly more money, 400,000 euros, for failure to limit access to patient records. Here, the hospital, rather than take a look at what patients were in the hospital at any given time and what doctors were treating those patients, the hospital simply gave any doctor who had ever treated a patient at this hospital full access to every patient's electronic health record. So if you'd ever been in this hospital as a physician and practiced there, you could then look at the records of any patient, whether you treated that patient or not. That obviously was a bit excessive, and the data authorities in Europe find this hospital a significant fine. The biggest one to date has been in France. Google was fined 50 million euro for failing to provide information about how data was being used. That is, they found that the consent process was inadequate to notify French users of Google how their data was going to be used. And lastly, this one is important and interesting and distinctive, because a digital marketing company in Poland was fined 220,000 euros, so a pretty significant fine, for failing to notify 6 million users that it was aggregating profiles based on publicly available data. Now, you may ask yourself, aren't there hundreds and hundreds of companies here in the United States whose business model is to aggregate public data and create advertising profiles or credit profiles, for example? The answer to that is yes. And under GDPR, that business is illegal. Now, those companies transact business here in the United States, and therefore they are not necessarily subject to GDPR. However, if a nationwide GDPR-like framework were to be put in place, there is the potential that such a framework would render this entire industry, illegal overnight. Let's look at comparing GDPR and CCPA. I want to look at who's covered, what the individual rights are, what does that mean for you and your vendors, and how can you comply with both? So, who's covered? GDPR applies to entities processing personal data of controllers established in the EU. That is, if you're working with data from the EU or within the EU, entities processing personal data of EU residents and citizens, or entities processing personal data in a place where jurisdiction exists. The second prong is the most interesting one because, for example, it doesn't limit where the person is. It's extraterritorial in the long arm statute. So, for example, I will use myself here as an example. I have dual citizenship. I am both an American citizen and a German citizen. And because I am a German citizen, GDPR applies to me, even though I'm sitting here in Old City, Philadelphia, and I'm, when I sign up for a new service, I don't have to disclose my citizenship. However, GDPR applies. And so that can pose problems for someone who has not built GDPR requirements into their app framework, for example. So if you are intending to differentiate between EU and non-EU citizens or residents for the purpose of GDPR compliance, it necessarily means that you have to capture that data at the time your customer signs on to your service, because failure to do so could lead to significant fines. I think the preferred method, and the one that I advise my counsels, my clients to follow, is to bake GDPR in and to apply it uniformly. That way you're not having to pose the question of, is this person a European citizen and therefore subject to GDPR? CCPA covers a slightly different cohort. It applies to for-profit businesses, not nonprofits or governments. Notice the distinction there, because GDPR will apply to nonprofits or to government entities that collect consumer personal information and do business in California. And these are the prongs, these are and, not or, have annual gross revenues of 25 million, or hold personal information on 50,000 or more consumers or devices, or derive 50% or more of their revenue from the sale of personal data. Now, the last one makes sense. It's math. Do you derive more than half of your revenue from the sale of personal data? If the answer is yes, it applies to you. The first one, do you have gross revenues of $25 million or more? If the answer is yes, done. The last one, or the middle one, is a little tricky, because you'll notice I said 50,000 consumers or devices. So in the world today, each of us has most likely more than one device. We may have a phone and a laptop and an iPad and maybe an Android Wear Watch or an Apple Watch. Each one of those counts as a device. So if one user has 5 devices, it doesn't take a whole lot of users to add up to 50,000. So you have to be very cognizant of how many data points you're capturing about your customers and your users, and how many nodes they're connecting to your software. Because if you are capturing multiple device points, you're going to get to that 50,000 limit pretty quick and then be subject to CCPA. So what is covered? Under GDPR, any information relating to an identified or identifiable person, EU resident or not. That is, if you are in the EU, if say an American travels to Europe, but they're in the EU, they're subject to GDPR. Similarly, if I, as a European citizen, am here in the United States, I am subject to it, or I'm entitled to the rights under it. CCPA's got a slightly different definition. It's information that reasonably could be linked directly or indirectly with a particular California consumer or household. And that's where it gets interesting, because the definition of what information gets covered is going to be is a little bit more expansive under CCPA, as we'll see on the next slide. And coming up, I'm sorry. What are the rights that an individual has under GDPR? You have the right to be informed that your data is being collected and why. You have the right to access that data. You have the right to rectification. That means correct mistakes. You have the right to erasure of that data, to have it purged from your system. You have the right to restrict processing of your data by algorithm or other machine process. You have the right to take your data to a competing or complementary service. You have the right to object to your data even being present. You have the right to have automated individual decision-making. So this comes up often in financial services transactions, where you might have an algorithm making a decision as to, for example, the creditworthiness of an individual. Under GDPR, that person would have the right, a subject would have the right to have an individual determination made, as opposed to batch processing through an algorithm. You also have the right to withdraw consent at any point to the date your data having been collected. That is, you may consent at the time you sign up, but you decide a year in, you want to withdraw your consent and close your account. You have the right to do that. In CCPA, your rights are more limited. The business has the obligation to inform you of what they're doing with your data. You have the right to request to see what data a company holds on you, although that's limited. You have the right to delete data that a company holds on you, and you have the right to opt out of processing. Now, how do you comply with both? Because they're very different frameworks in a lot of ways. So CCPA, for example, looks at not only individuals, but households and things like browser profiles to identify people. GDPR doesn't really do that. So my advice to clients is to think globally rather than looking line by line at the individual statutes. Look to incorporate both into one uniform privacy policy and framework. That way, you're prepared for any eventuality. My advice also is to combine the specific requirements and modalities with GDPR's very specific contract requirements. For example, GDPR requires you to have specific model language in your contracts. CCPA does not have such a requirement. So combining both into one forward-looking privacy analysis, looking for gaps to make sure you're capturing the entirety of the framework. All right, let's transition to our last topic, which is section 230. This is something that has been in the news a lot lately. It is, you've heard about it a lot in the context of politics. You've heard a lot about it in the context of people complaining about moderation on social media, for example. It is not an exaggeration to say that Section 230 allowed the internet to become what it is. And I'll be specific. It was part of the Communications Decency Act of 1996, signed into law by President Clinton. Basically what it says that companies that operate online cannot be considered publishers of user-generated content that others put on their site. That is everything from Facebook posts to restaurant reviews to online chats and games to tweets to things in your IGDA Discord server are not published by the host that hosts the content. That's important because under Section 230, companies cannot be held liable for what others choose to post on the sites, even if those posts are unlawful or offensive or false. So Section 230 boils down to 26 words. It's a very short sentence. I posted it here in its entirety because it's really not very complex at all. And I'll read it. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Very simple. And this is important because if you are the publisher of content, you can and often are held liable for inaccuracies, for defamation, etc. It's why newspapers, when they make a mistake, have to post a retraction. Now, if you make a mistake in a Twitter post, you don't have to post a retraction. And Twitter can't get sued if you go on Twitter and post a racist screed. All of that is because of Section 230. Section 230 is literally why the interaction with services, basically every service that you interact with on the internet today, is enabled because of Section 230. It basically gives companies the right to moderate content on their platforms as they see fit. And this is where it gets really important, I think. Section 230 was never designed to keep online forums neutral, and I use that in quotes because this is where things have come up in the context of recent politics. Section 230 was not an extension of the First Amendment. It has nothing to do with that, in fact. Instead, it's very specifically crafted to allow these platforms, which are all private entities, to moderate content however they see fit, with basically no regulation to confine them. It's perfectly legal, as I said here in the slide, to claim that COVID-19 is a hoax or that the 2021 election was stolen, and it's legal to post racist, sexist, and homophobic content on the internet. All of that is legal. Whether it's right or wrong, it's legal. It is also perfectly legal to ban users from a website for doing any of those things. Again, that's where Section 230 gives you the discretion to do so. And also, these are private companies doing it, not the government. So claims of censorship are dead wrong because Section 230 has nothing to do with the First Amendment. Now, who wants Section 230 changed? Well, a lot of people for a lot of reasons. Both sides of the political aisle have expressed reservations about 230. Former President Trump and others on the right have said that tech companies are silencing conservatives, which they don't. They're moderating speech on their platforms to avoid things like incitement to violence. Politicians on the left have attacked Section 230 because they feel that it allows the spread of hate speech and harassment, and it does. If things like Gamergate or the Unite the Right rally in Charlottesville have taught us anything, it's that hate speech flourishes, thrives on the internet. Whether it's in the Discord servers where the Unite the Right rally was conceived of and organized, or in the Twitter feed of our former president who incited a riot on the Capitol. there is hate speech on the internet, and platforms have allowed that to propagate. So what happens if Section 230 is changed? Well, I mean, it's for better or for worse, sites that are going to have to change how they handle libel, child pornography, online harassment, illegal gun sales. These are extreme examples. However, every single aspect of transacting business on the internet is potentially going to be disrupted. If Congress successfully changes 230 so that websites are liable for user-generated content, there are two sort of schools of thought as to what's going to happen. One, the current online giants, and by that I mean Facebook, Twitter, Amazon, Google, Apple, are going to get more power, and they're going to tighten their restrictions, and they're going to moderate content more. Or the internet's basic business model is no longer going to work, because anytime somebody sees content that they believe is defamatory or misleading or whatever else, there's going to be a lawsuit. And all of those lawsuits are going to put companies out of business because of the threat of a 230 lawsuit. So the question that I will leave you with, and I think we'll end with tonight, is which one of these outcomes do you think is better? I don't have strong feelings one way or another. I think I would be inclined personally, and this is my opinion, to leave 230 as it is and to impose moderation standards instead. However, that raises all kinds of questions as to whose standards you're imposing. If I were king, it would be easy, but I'm not king. We don't live in a monarchy. And so societal norms are going to have to govern, and that raises serious questions as to whose norms we're going to apply. But the question of changing 230 is fundamental to transacting business on the internet. And if you have an app or a game or a SaaS service that does business on the internet and gathers any kind of user-generated content, watch this space, because this Section 230 amendment it poses an existential threat to life on the internet as we know it. With that, I will put up, this is how you can get in touch with me. Our website is baileyduquette.com. You have my email address and my phone number, and @Matanovic Law is my Twitter handle. Feel free, if you have specific questions that you don't want to ask me in this forum, please feel free to make use of my email or phone or Twitter, although that's public, obviously. But I would welcome any specific questions, or if you have a specific inquiry about your company or an idea that you have, I would love to hear from you as well. And with that, I will stop sharing my screen, and I guess we'll open things up to the Q&A section.
Yes, and we have two that have queued up from Jason, who is on the IGDA board. First, we'll just go by.
Okay, I've got it in front of me.
All right, cool. Go ahead.
Is there a minimum? The first question is trademark protection. Is there a minimum threshold required to register a trademark? How small is too small to register? I guess I respond to that with a question. Do you mean in terms of dollar or how you intend to use it? From my perspective, if you intend to do any kind of transaction on the internet or in commerce, in interstate commerce, which is the threshold, if you use the mark in commerce, I think it's worth protecting. I mean, it costs money to register a trademark. There's a filing fee of $225 per good for which you seek registration. So if in your opinion, you're not going to recover that, or it's not worth protecting, then yeah, it's probably not worth doing that. But I think if you're at all interested and you think there might be a commercial value in a mark, yes, I think it's worth protecting, because without protection, anyone can use the mark. The second follow-up is also from Jason regarding fair use. YouTube creators are frequently hit with automated copyright claims, and Twitch recently dealt with automatic copyright music claims with a rather heavy hammer. Yes, correct. I've seen that. Do you see potential changes either on the content platforms or in federal or state legislation to tamp down on frivolous copyright claims? Or is it getting worse? It's getting worse, unfortunately. And part of the problem is the automation. I think that platforms have not, the way that platforms respond to a copyright claim today, and I say this, and in the interest of full disclosure, I've been on both the giving and the receiving end of takedown requests. So I've sought to protect my own clients' intellectual property by issuing copyright strikes, and also been on the receiving end where my clients' video was demonetized because of a copyright claim that we thought was frivolous. The limitations of the platforms right now and the automated nature make it basically impossible to contest a copyright strike. And this is because of the volume. So there's no way you can have a human look at every single copyright strike. There's just way too many that happen in the world. So it is both a question of automation, and I think there's skittishness, right? For example, companies respond to a copyright strike by immediately taking it down, because if they don't, they can be found to be publishers. That's part of the 230 loophole. However, a company that takes down an improperly filed copyright, a company that takes down content based on a frivolous claim would have a lot of problems, and they don't really respond to. I mean, I've been dealing with one particular video where the video was taken down. It's been 2 months now that we're trying to get the video back up because it's monetizable, and every single other video that this person creates is monetizable, and we've made the argument that their use of a copyrighted song is fair use. So it's tough. Do you want to go to Rob's question on the mic or Daniel's written question? Either one.
Well, we can start with Rob. We're actually going to add it to the Q&A in just a second, but since you can see it, yeah, if you want to start with Rob, we'll do that since we're up first.
Oh, here we go.
Yeah.
Are there, and is that the one that just came in, anonymous
Yes.
attendee? Okay.
Yep.
For IP and copyright in games, are there any practical moves a small developer can make to protect themselves from copycat versions of their game, such as either like a preventative move or after a copycat has been released? This is tricky because you can copyright an idea, but you can't copyright the thing itself, right? So, you know, when this pops up obviously very often in the context of a successful game in an app store, where, you know, for every Flappy Bird, there are 1,000 copycat games. And really, unfortunately, there are not a lot of protections. You can certainly trademark things like game titles. You can, if there is a specific game mechanic, you can seek to, or character name, for example, you can seek to trademark that. But there's unfortunately not a lot of protection with regard to things like platformer games. Now, if you're writing a story-based game, you can certainly register a copyright in the story that you're telling, and but that wouldn't work for like a simple platformer like Flappy Bird or Crossy Road or things like that, that are the kinds of games that get copied constantly. Let's go to the question from Daniel Johnson. If I wanted to copyright a game, would I be able to do so with the entirety of all that content, or would I have to copyright each piece? I will. It's hard. That sort of follows on the game, the answer that I just gave. You can copyright the code, although in the world that we live in today, where people are absolutely constantly iterating on code, it becomes tough to stay up to date with your copyright. If you're iterating every quarter, working in sprints, every sprint you publish a rev, then it's hard to keep up. The question becomes, if you're innovating an idea and you promote it, that's easier to defend. What's the next question? From narrative documents to 2D or 3D art assets, either released in a published game or posted to the marketplace, can those be protected? Yes. You have a copyright in those assets the moment you create them, and you can seek to register them at the Copyright Office individually. Thankfully, the filing fee for filing a copyright is a lot smaller than the trademark. I think right now it's $35 per mark. So it is a lot more feasible and economically manageable to register hundreds of copyrights than it is to register hundreds of trademarks. Also from Rob, for GDPR CCPA, if a small game dev is going to release and operate a networked game with user accounts or have a forum for their users, what are the baseline measures they should be aware of? Do not, if you can at all, not store any user data, identifiable user data, don't do so. If you're going to store anything, you have to get full, complete consent from every user. I would apply GDPR and CCPA worldwide. I wouldn't go through especially for a small dev, I would not go through the time and effort to try to distinguish between EU versus non-EU users. How does copyright law apply to content that is generated as a collab or via a crowdfunding platform? So the content generated as a collaboration is the property of the creators. So if it's 5 of you who collaborate on a software project, the 5 of you own the copyright. Similarly, the crowdfunding platform question it depends, because there may be license restrictions from the crowdfunding platform. That is, some may require you to apply an open source license, for example, where that license controls the intellectual property rights as opposed to an individual owning that right. So it really depends on the platform itself. I guess Rob's question up there for 230. In your opinion, how likely is it that 230 remains as is? Well, I think it's more likely now in the post-Trump era, but I think there is enough. I think there is enough momentum on both sides of the political aisle that there's going to be some change. I don't know. I don't have a lot of confidence to tell you what that's going to look like, because I think the squeakiest wheels on the right basically want to abolish it and hold people to account for moderation, and that's never going to happen. It shouldn't happen, at least. And I think the squeakiest wheels on the left basically want to use moderation as a cudgel and force people into banning speech they don't like, and that probably shouldn't happen either. Obviously, the more common sense result is that some kind of middle ground be formed, but of course, Washington is not a place that I would say is renowned for common sense results. So I think at this point, your guess is as good as mine. 230 is not right now the priority. There's an impeachment going on. We're still in the middle of a pandemic. There's a lot of problems in this country that are greater than 230. However, I think if the disinformation campaigns over the last 2 election cycles has taught us anything, it is that moderation on social media platforms is really important. And the question of who does that moderation and under what standards is going to continue to be very, very relevant, both in politics and on the internet for a long time. So the question from Jason is to hop on Rob's question regarding GDPR CCPA. If a small game developer has a Discord or similar third-party communication platform, do they have to take precautions regarding personal information, or does Discord handle most of those responsibilities? I am not a Discord user, but I believe Discord handles unless the organizer of the server is his or herself gathering information and storing and processing that information, then Discord would handle everything. So I think when you sign up for Discord, you need an email address, probably a phone number, and I think they have a real name policy. I think that's one of the sort of post-Charlottesville changes they implemented. I don't think that you as an organizer of a server get access to that information, nor do I think you have responsibility to store it. So I think that is all under the purview of Discord. From Rob, many students want to commercialize a game project. Is forming an LLC the only practical way to resolve potential profit sharing or similar business issues? Well, forming a corporate entity of one form or another makes a lot of sense. And I hedge there because an LLC may not be the best or most practical avenue, depending on what your plans are for whether you want to take on investors or whatever else. I strongly feel, however, that corporate formalities are really important. If only because nobody goes into a project intending to have a fight with their potential business partners and end up in acrimony, right? Just like nobody goes into a marriage intending to get divorced. However, we all know businesses break up, marriages end. And so having the corporate formalities straightened out, who gets what, who has to do what, et cetera, before you start or at the very beginning, will, in the best of times, it means that you never have to look at these papers again because you're swimming in money and everything is going great and you're all happy. However, as more often happens, something, you hit bumps in the road and you have to decide, how to take on a new partner or how to take on a new investor or how to get rid of a partner. Having all of that written out, prescribed in a legal document that you all agree to, makes that so much more easy. I've gone through a number of these sort of corporate divorces, and I will say that none of them have been easy for the participants, but I will say that the ones where we avoided litigation because we knew exactly what everybody's rights and obligations were the ones that were the least destructive, because those were the ones where everybody knew what they wanted. They were still mad at each other and everybody was sad, but at least, we minimized and avoided litigation. We minimized cost and avoided litigation. So there's a question here in the chat. Hold on here. I need to make my chat window a little bigger. This This is from Jason C. As far as I'm aware, basic game mechanics are not copyrightable, but some specific functionality has been patented, such as Namco patenting load screens and gameplay from the mid-90s to the mid-10s. Well, so patents are a very specific area of law. I will, in full disclosure, I am not a patent attorney. I am not admitted to the patent bar, and it's not an area of the law that I practice. However, there have been a lot of attempts to patent basic mechanics, both in the gaming area as well as in, Apple has a patent on the pull to refresh functionality that you see in basically every app across every platform now. That's an ongoing thing. There are questions raised in patent law every single day as to whether basic functionality like this can, or more importantly, should be patented. That is you take 10 lawyers, you'll get 10 opinions and 10 thoughts on how it should be resolved. I think patenting a load screen is kind of garbage. That's my personal view. I think patenting pull to refresh is kind of garbage. I think patenting the construction of a cell radio, that makes more sense. Patenting an algorithm that does underwriting decisions, that makes more sense than patenting a load screen. But that's my decision. Yes, I mean, and that's Rob's follow on here is that obvious solutions should not be patentable, and that's an open question that is constantly in flux. And what constitutes an open and obvious solution is a question that the courts wrestle with constantly. Jason, another question here. Are Apple's upcoming privacy changes to apps running on iOS going to negatively impact financial returns from advertising networks that are integrated into a lot of mobile games? Or are ad networks overblowing the reality of the changes? I'm of two minds here. As a consumer, I love these changes because it lays bare how much these companies have been abusing us and our data forever. I think it's great. I think that having to opt in at every turn is going to make users rethink the value of what they give to these services. And I think it's wonderful as a user. As somebody who advises companies who do business on the internet, it's troubling because there are existential threats to some business models. I think it's going to require people to be a lot more upfront with their users and their customers about what they gather and why. Nothing prevents you from advertising, collecting your customers' information and advertising to them based on that. You're just going to have to get their permission. That's really what it boils down to. You're asking these people's permission. Facebook is all up in arms, and Mark Zuckerberg is on TV and writing op-eds about how they're some anti-competitive thing. No, Facebook is just what it boils down to is that Facebook is going to have to tell its users what it collects and what they do with it. I don't see that as a problem. I think if you are on the edge of being shady and you are skirting the rules and you are cutting corners, yeah, it may be a financial impact. However, if you're upfront with your users, and you've always been upfront with your users, I bet this helps you. And I bet you if it will become a differentiating point in the marketplace where respectful, fully transparent disclosure becomes an upsell and not a detriment. That's my opinion. And it's certainly when I'm exercising my my discretion with my dollars, I absolutely go to entities that are much more open and disclose their use ahead of time. And again, I think this is only going to help in terms of overall quality of stuff. Yeah, I mean that's a question, right? I mean, with the news that Google Stadia is probably going to be closed down soon, you know, getting services for free or for little cost, that's a question. I, for one, you know, I don't use Google services at all for that reason, because I don't think that anything we put into the Google machine, you know, I think I should be compensated for it. I don't use Google for search. I don't use Google for email or anything else for that reason. I pay for software. I want to pay for software because I know that if I pay for something, I can hold the party that I've paid the money to accountable for that transaction. Whereas if I'm getting a free Gmail account or free search results, I'm not. So yes, I agree that paying for those services makes it, you create a transactional relationship with the person you're buying from, and it creates some accountability there. Also, it allows lots of my clients who make their living writing software to make a living. I mean, I think the people freaking out because somebody wants to charge $4 for an app is like the most disrespectful reaction I can conceive of. Like $4 for an app that they've spent hundreds of hours coding. Give me a break. I'm all for paying for software. So here's the next question. What is, hold on, I just scrolled all the way to the top. I'm sorry. There was a movement that seems to have faded to have end user agreements restated in plain language. Even if a company is upfront, it won't matter to many if it is buried in multiple documents that only lawyers can understand. I only write plain language EULAs. When I write a EULA for you know, something I do regularly, I write them in plain English. I don't like legalese. I think legalese is sloppy and boring. You are either lazy or you're trying to hide something if you don't write your EULA in plain English. That's my view.
Nice, I like that. So many good comments and good questions all around. All right,
Absolutely.
I have a question myself,
Please.
and I can't post to these things, and mine's a little specific to me, you know, that I know some of my fellow board members probably know where this is going. So I want to go back to your explanation on the of the public domain. So I'm
Yes.
making a game currently that's based on the comic Little Nemo and Slumberland from 1905. It's been in the public domain now for a couple of years, but prior to becoming public domain, there were a couple of other media that were licensed out by the former owner of the IP, most notably an animated film from a Japanese animation studio and an old video game for the original Nintendo. One thing that we are being very careful about is only lifting elements from the original comic itself. Nothing from the movie, nothing from the video game, because those elements are still owned by their respective property holders. The
Yes.
comic is in public domain, not the other media. I was wondering if you could go a little bit more into the specifics of that. Like, where do the blurred lines exist? If someone wants to make a game based on, say, Sherlock Holmes, they're not accidentally infringing upon, like, the Robert Downey Jr. movie, the Cumberbatch show, et cetera,
Right.
et cetera.
So I'll use Sherlock Holmes because it's an example I have personal experience with. One of my clients is a publishing company, and their first book was a reissue of the novel with new illustrations and a new publishing. And we were very careful and specific to use only the Arthur Conan Doyle text with the new illustrations that they paid an artist to illustrate. And the mandate to that illustrator was use the text. Do not, you know, it's hard because it's like, don't look at that elephant sitting in the corner. Of course, you're going to look at the elephant because there's an elephant in the corner. But it's harder with things like the Downey movie or the Cumberbatch show, where they've really entered sort of the sort of media zeitgeist. It's a little easier when it's you know, I don't mean to minimize your project, but it's a more obscure source material than something as prominent as Sherlock Holmes. I can't wait to see it because it sounds fascinating. But you know, I think, you know, a game like Cuphead, for example, was inspired by any number of you know, cartoons from the 50s and 60s, but made really damn careful. They were very, very careful not to pull on, not to pull from specific instances. All of that was new IP. All of that they created themselves, which I mean makes that project amazing. So I can't wait to see your project. It sounds beautiful, as this other commenter said. But yeah, no, I think definitely sticking to the original source material, as long as that's an open source or in the public domain, and not deviating or referencing the non-public domain materials is this comment's great. Sherlock Holmes having emotions.
Right.
Yes, the latter stories might still be under the estate's copyright. That's right, but the original novel is not.
Yeah, it gets really tricky, which is fun.
No,
I'm not gonna.
It's incredibly tricky, especially for pre-1978 works, because the rules are. I mean, it's like reading tea leaves as to figuring out what the requirements are. Because the laws were amended multiple times, and you have to figure out what it's just really complicated.
And I won't turn this into a marketing thing for myself, but Nemo thing is out there and floating around. We put our first trailer out soon, so if you
awesome.
look that up, please go.
I would love to. Thank you. Awesome. I will.
Okay. So thank you all again so much. I don't think we have any other questions coming up. We've got like 10 minutes left. If anyone does have any like last things they want to throw out there, just double check before I close this prematurely.
If I can pop in,
go ahead, Robert.
Since I have the power. On the copyright stuff, you know, Disney extended it more than once. I feel like if I were to ask, is it going to be extended again? I feel like of course Disney's going to extend it again because they want a 1,000-year empire. But is there a chance they could be stopped? Or will business like that win and we will lose the ability to have public domain eventually? Because that's my fear, is that they'll just keep extending it as soon as they're in danger of losing their very profitable IP.
I think as long as money plays the role that it does in American politics, it is a possibility. I mean, that's a cynical answer, right? But you know, I think the Citizens United decision, which basically allows unfettered corporate money to affect elections, makes it really difficult to limit the lobbying power of the Disneys of the world. And it's not just Disney, it's, you know, it's Sony, it's lots of huge IP holders. So yeah, I mean, it's a very real possibility that it's going to be basically a perpetual copyright, and that there will be no such thing as public domain anymore. That's it's a scary prospect, but that's a very real one.
Yep.
Thank you for that. I feel, Stephan, like we've cornered you at a cocktail party and just start asking you all our legal questions.
I mean, that's fine.
Extremely nice about doing all of
this.
It's
like a doctor at a party is like, what? Look at this rash. It's just yeah, no,
thank you.
You're very welcome. I appreciate very much your inviting me here tonight and letting me talk to. I could nerd out on these topics for, like I said, for hours. So if you have more specific questions about specific projects, or if you just have questions about the topics in general, please do not hesitate to reach out. I would love to talk to all of you.
Well, I'm actually going to take you up on one last thing. This just struck me. I wasn't going to ask this, but I figured Adrian asked his specific question. I'll ask one of mine. So,
by all means.
So I run the game program at Drexel University, and we celebrate our alumni and the projects that they've worked on by hanging posters in the hallway. And so we go on the internet and we get key art of those projects, and we put their names up, and they're just printed and hung in the hallway. However, especially with these remote times, I want to celebrate these alumni in an online image gallery. So I want to take those posters that use other people's IP art and promote our alumni's involvement in them by putting these posters online. And I've got some people nervous in the university about doing it that way. I'm not asking for an official thought. I'm just sort of like, what do you think? Your loose opinion. I won't hold you to it, obviously.
I think that is arguably, I think that you could make a very strong argument that would fall under fair use, because you're promoting you're not doing it for commercial gain. You're promoting your program and the success of the alumni. We see that all the time with universities, for example, promoting their alumni who are athletes. They talk about the teams they play for, et cetera. Or if people who are journalists, the university will promote or at least use the affiliation, the journalistic affiliation, whether it's New York Times or CNN or whatever else. Those are trademark names. So I think an argument could be made that those assets are fair use. Now, ideally, if you're going to promote this in the big scale, I would think about that maybe, getting clearance. But it's not, I think an argument could be made, or not just could be made, but I think a strong argument could be made that is fair use.
Okay, cool. Thank you.
You're welcome.
Appreciate the thought. I appreciate it.
No, of course. And again, if that's something you want to pursue more specifically, I'm happy to do so offline too.
All right, cool. Thank you so much, Stephan. I appreciate it.
You're very welcome. I'm happy to talk to this group, and I thank you for inviting me tonight.
Thank you so much for joining us, Stephan. I really appreciate it. This was great. We covered so many different topics, and like Jason said, definitely some excellent insight. And again, for everybody out there, remember you have access to Stephan's slides. Go check those out. Be sure if you have questions, like I said, feel free to contact him. Again, thank you so
You're very
much.
welcome.
Everybody, have a good rest of your night. We will talk to you all soon about the upcoming March meeting, as well as the ongoing project, which is the Philly Makes Games website. It was all great having you all. Everybody, have a great night.
Good night.